Welcome to the Pencil Bob channel. I hope you enjoy my stories.
The drive out had taken longer than Walter remembered, though he suspected that had less to do with the roads and more to do with the fact that he hadn't made this particular trip in nearly 7 years. Hadn't felt the urgent pull of it until recently when retirement stopped feeling like a distant concept and started feeling like something with an actual date attached to it. He was 61 years old, still broad through the shoulders, still capable of a full day's physical work if the situation called for it, and he had spent 4 decades building a contracting business that now employed 40 people and had his name stenciled on the doors of vehicles across 3 counties. But the land had always been the plans. 2,000 acres, give or take, held by his family for over 100 years, purchased by his grandfather back when purchasing land meant something weighted and permanent. A declaration made to no one in particular that this ground belonged to these people and would continue to do so. Walter had rough sketches of the house he intended to build. A real house, not a cabin. Full front porch, wood stove, room enough for his sons and their families to visit without anyone feeling like they were in each other's way. He had a builder in mind and had been quietly pricing materials for the better part of 2 years. Margaret would have loved it out here. He let that thought pass the way he had learned to let those thoughts pass, and kept his eyes on the road as it curved northeast through what should have been deepening forest canopy. Except the canopy wasn't there. He slowed the truck before he fully understood why, some instinct registering the wrongness of the light before his conscious mind had caught up with it. The road curved and opened up, and Walter felt the breath leave his body in a long, slow exhalation that was not quite a sigh and not quite a curse. The forest was gone. Not thinned. Not logged in any selective or considered way. Gone in the industrial and total sense of that word. Cleared by heavy equipment, operated by people who had felt absolutely no obligation to what had been standing there before them. In its place, laid out along a grid of freshly paved roads that curved with the artificial casualness of subdivision planning, were houses. Hundreds of them. Walter pulled his truck to a stop at the entrance and sat with the engine running. The brick monument sign in front of him was flanked by ornamental grasses and a small recirculating waterfall feature. It read Pinecrest Estates in raised bronze letters, and below that, Pinecrest Homeowners Association, established for the benefit of our community, with a phone number and a logo that incorporated a stylized pine tree, which Walter stared at for a long moment with the kind of stillness that in another man might have looked like calm. He called the number on the sign. The woman who answered identified herself as Karen Marsh, president of the Pinecrest HOA, and she had the particular telephone manner of someone who was accustomed to being in charge of things and wanted that established immediately. Mrs. Marsh, Walter said, keeping his voice level, my name is Walter Cobb, and I am currently sitting in the entrance to your subdivision, which appears to have been built on approximately 1,200 acres of land that my family has owned for over 100 years. There was a brief pause on the other end, the kind of pause that precedes a certain type of response. Mr. Cobb, she said with exaggerated patience, I'm not sure who gave you that information or where you've gotten the idea that you have any claim to property in Pinecrest Estates, but I can assure you that every square inch of this development was legally purchased and properly permitted, and if someone has been telling you otherwise, they have done you a tremendous disservice. I have the original deed, Walter said. I have every tax record going back to 1921. I have survey documents and title history, and I am looking at my land right now through my windshield. What you're looking at, Karen Marsh said, and her patience had developed a distinct edge, is a planned residential community of 412 homes with assessed values averaging $380,000. And I suggest that before you make any further accusations, you consult someone who can explain property law to you, because you are clearly confused about the situation. Walter looked at the pine tree logo on the sign for another long moment. I'm not confused, he said, and ended the call. The developer's office was listed on the subdivision's website under a company called Meridian Land Group, and the man Walter reached there was smoother than Karen Marsh, but delivering the same essential message wrapped in more expensive language, explaining that the land in question had been acquired through a fully documented sale completed approximately 5 years prior, that the development had been permitted and constructed in full compliance with county regulations, and that if Mr. Cobb believed he had a legitimate grievance, the appropriate venue for that grievance was the civil court system. We'd encourage you to think carefully before pursuing that route, the man added, in a tone that managed to sound both reasonable and threatening at the same time. Because litigation of this nature tends to be lengthy and expensive, and we have a legal team that is very well prepared to defend our position. Walter thanked him politely and drove to the county courthouse. The records office confirmed what he already knew and added something he hadn't expected, because buried in the filing history was a bill of sale dated 4 years ago bearing what was supposed to be his signature transferring the full parcel to a holding company he had never heard of, notarized by a notary whose stamp he didn't recognize, witnessed by 2 names that meant nothing to him. His own name on a document he had never seen, selling land he had never agreed to sell. He sat in the parking lot of the courthouse for a while after that, watching people come and go through the glass doors, and he felt the full weight of what had been done to him settling in with a clarity that was almost physical. They hadn't just built on his land. They had forged the paperwork to take it from him first, and then built on it, and had been living comfortably behind that forgery for years, apparently confident that Walter Cobb would never show up to ask the wrong questions. He called his son David on the drive home. "I need a lawyer," he said, "and not the kind I've been using for contractor disputes. I need someone who handles property fraud because that's what this is, and I need them to understand that I'm not going away." David asked him what had happened and Walter told him, and when he finished, there was a silence on the other end of the line that lasted several seconds. "Dad," David finally said, "are you sure about the signature?" "I have never signed anything related to that land," Walter said, "and I never would have, and whoever put my name on that document knew that, and did it anyway because they were counting on me not finding out until it was too late to matter." He drove the rest of the way home with the windows down, the way he always did, and he thought about the trees that were gone, about the old growth sections his father had walked him through as a boy, pointing out chestnuts and oaks that had been standing since before the Civil War, trees that had taken generations to become what they were, and that had been cleared in what was probably a matter of weeks by men and machines who hadn't given them a second thought. That perhaps even more than the houses and the forged signature and the smug voice of Karen Marsh on the telephone, was what settled into Walter's chest that evening and stayed there, hard and permanent, like something load-bearing. The lawyer Walter found was a man named Phil Garrett, who had been practicing property law in the county for 30 years, and had the kind of office that suggested he had never felt the need to impress anyone. Mismatched furniture, walls lined with case files in labeled binders, a coffee maker on top of a filing cabinet that appeared to have been there since the Clinton administration. What Phil Garrett did have in abundance was a reputation for being meticulous and relentless in equal measure. And when Walter spread his documents across the conference table and walked him through everything, Garrett had listened without interrupting, which Walter took as a good sign. "The signature is the key," Garrett said when Walter finished. "Everything else they've done, the permits, the HOA formation, the individual home sales, all of it flows downstream from that one fraudulent document. You pull that thread hard enough and the whole thing unravels." "Then let's pull it," Walter said. What followed was nothing like Walter had imagined litigation would be, and he had imagined it would be bad. It was worse. The discovery process alone consumed the better part of 8 months, a grinding procedural war fought entirely on paper in which Meridian Land Group's legal team, a large regional firm called Hartwell & Prout with offices in 4 cities and a client roster that included several of the state's largest developers, deployed every tool available to make the process as slow and expensive and demoralizing as possible. They filed motions challenging the scope of discovery requests. They filed motions challenging the admissibility of Walter's historical deed documentation on technical grounds that Phil Garrett described as creative but ultimately baseless. They requested extensions and then requested extensions of the extensions, each one eating another 30 or 60 days off the calendar, while Walter's legal bills accumulated in a folder on his kitchen table that he had stopped opening with any regularity because the numbers inside had begun to affect his sleep. Hartwell and Prout knew exactly what they were doing, and they were very good at it. The strategy was not complicated, and it wasn't meant to be. It was meant to be obvious enough that Walter could see it clearly, could understand that the firm intended to keep him in procedural limbo for as long as it took for his finances to give out, at which point the case would collapse not because he was wrong, but because he had run out of resources necessary to keep being right. It was a form of institutional violence dressed in the language of due process, and Walter recognized it for what it was within the first 3 months. He refused to do that math on settling. But the bills kept coming. It was during this period that Karen Marsh decided to make his life additionally complicated, and she approached that project with the same organizational energy she apparently brought to running the Pinecrest HOA, which was to say thoroughly and without any apparent self-doubt about whether she should be doing it at all. The calls started first. She called on a Tuesday afternoon while Walter was in the middle of reviewing a job estimate, and he answered because he didn't recognize the number, and she introduced herself in the bright, authoritative tone of someone who had spent years running meetings and expected that tone to set the terms of any conversation she entered. Mr. Cobb, this is Karen Marsh. I'm the president of the Pinecrest HOA, and I think it's past time you and I had a direct conversation about what you're doing to this community, she said, without any preliminary pleasantries, as though she had rehearsed the opening and didn't want to waste time getting to it. Mrs. Marsh, Walter said, anything you need to say to me should go through my attorney. I'm not calling as a legal matter, I'm calling as a neighbor, she said, pivoting smoothly. Because whether you want to acknowledge it or not, 412 families are lying awake at night because of a lawsuit you filed. Families with children, families who saved for years to buy their homes. And I think a decent man would want to know the human cost of what he's doing before he goes any further with this. Walter told her again to contact Phil Garrett and ended the call. She called back the following Thursday. I've been speaking with the homeowners, she said, as though the previous conversation had not ended the way it had. And I want you to understand that these are not wealthy people, Mr. Cobb. These are teachers and nurses and young couples who stretch their budgets to buy into this community. And what you are proposing to do to them is frankly unconscionable when there are other ways this could be resolved. What ways would those be? Walter asked, because he was curious what she would say. A reasonable financial settlement, she said immediately, which told him she had prepared for the question. Meridian is prepared to offer you fair compensation for any legitimate claim you can demonstrate, without dragging 400 innocent families through years of litigation and uncertainty. That's the adult way to handle this. Mrs. Marsh, Walter said, they forged my signature on a document and built a subdivision on land my family has owned for over 100 years. There is no settlement conversation that begins from the premise that what they did was a misunderstanding. What they did, she said, and her voice had cooled considerably, is purchase land that was legally available for sale, develop it properly, and create a community that has added $20 million in tax value to this county. And I would encourage you to think very carefully about whether a court is really going to side with one man's claim over the economic reality of what exists here. Walter ended the call. She called 6 more times over the following 3 weeks, and each call was a variation on the same themes: the families, the community, the economic argument, the suggestion that Walter was being unreasonable, with occasional forays into a softer register where she expressed what sounded like genuine concern for him personally, suggesting that the stress of litigation at his age was something he should discuss with his doctor, that she had seen what prolonged legal battles did to people. That she was saying this not as an adversary, but as someone who genuinely wanted a good outcome for everyone involved. He saved every voicemail. The emails were longer and more elaborate, arriving 2 or 3 times a week with subject lines that ranged from the formally legal sounding to the barely concealed emotional manipulation. And they were detailed documents that included photographs of Pinecrest families, children on bicycles, elderly couples on front porches, a block party with a banner that read "Our home, our community," alongside carefully worded arguments about the disruption Walter's lawsuit was causing to people who had done nothing wrong. He forwarded every email to Phil Garrett without responding to a single one. Then she started showing up in person, and that was when things acquired a different quality entirely. The first time was at his office on a Wednesday morning, when his receptionist Sandra came back to his desk with an uncertain expression and told him there was a woman in the lobby who said she was there on a community matter and needed a few minutes of his time. Walter walked out to the lobby and found Karen Marsh standing near the front desk in a blazer and slacks, holding a manila folder against her chest like a prop, and she looked at him with the expression of someone who has positioned themselves carefully and intends to make the most of it. I thought if we could just talk face to face, she began, without lawyers and formalities. Mrs. Marsh, Walter said, I've told you twice on the phone that any communication needs to go through my attorney. That applies here too. You need to leave. I have a petition, she said, opening the folder and producing several stapled pages, signed by 200 residents of Pinecrest Estates, asking you to consider mediation before this goes any further, and I think you owe it to these people to at least look at it. Leave it with Sandra, Walter said, and she'll see that Phil Garrett gets a copy. I didn't come here to talk to your receptionist. I know why you came, Walter said, and his voice was even and not unkind, but carried the absolute finality of a man who had been building things and managing people for 40 years, and had no uncertainty about where lines were. You came because you thought being here in person would make it harder for me to end the conversation. You were wrong about that. Please leave. She left, but she paused at the door and turned back with the look of someone delivering a prepared exit line. I hope you'll think about those families tonight, Mr. Cobb, she said, because they are certainly thinking about you. She was back 2 weeks later, on a Friday afternoon when Walter happened to be standing at the front window talking to his project manager, and he saw her in the parking lot before she came in, sitting in her car for several minutes, apparently composing herself or reviewing notes, before she got out and came through the door carrying a different folder and wearing the expression of someone who had decided on a new approach. This time she had a homeowner with her, a young woman named Ashley who Karen introduced as a first-time buyer and a kindergarten teacher and a single mother. And Ashley had clearly been coached because she spoke in a quiet, slightly trembling voice about how much the house meant to her, and how she couldn't sleep, and how her daughter had been asking questions she didn't know how to answer. And it was a genuinely affecting performance that Walter suspected Ashley believed completely. Which made him feel sorry for Ashley and considerably less charitable toward Karen. I want you to look at her, Karen said, gesturing toward Ashley with the confidence of a closing argument, and tell me that your claim to land you haven't set foot on in 7 years is worth more than her daughter's home. Walter looked at Ashley for a moment with something that was not hardness, but was not softness either. Ashley, he said, I'm sorry you're in this situation. Genuinely. But the people who put you in it are not me. They're the people who sold you a house on land they didn't own, and they are the ones you should be having this conversation with. Ashley looked uncertain, as though this framing hadn't been part of her preparation. Karen opened her mouth to redirect the conversation, and Walter looked at her and said quietly, We're done here, Mrs. Marsh, and went back to his office and closed the door. He called his son David that evening and described the visit, and David listened with the focused attention of a man cataloging information rather than just receiving it. She brought a prop, David said. A sympathetic homeowner. She's building a narrative, Dad. She wants a version of this story where you're the villain and she's protecting the community. Because if that narrative gets established, it creates public pressure and potentially jury sympathy if this gets in front of one. Phil says it'll be a bench trial, Walter said. Judge only. Then she's doing it for the press, David said. And because she genuinely can't stand not being in control of the situation. It was the following week that David made a call he had been turning over in his mind since the restaurant incident, when Karen had approached their table and he had sat across from his father and watched Walter handle it with a composure David wasn't sure he could have matched, and had thought for the first time that his father needed more firepower than Phil Garrett, however meticulous, could provide. The firm was called Brennan, Cole and Associates, and David had worked adjacent to them on a contract dispute 2 years prior, and had come away with a clear impression that Marcus Brennan operated at a level that most litigators spent their careers reading about but never reaching. He called Brennan's office on a Monday morning, got a meeting for Wednesday, and presented everything, the forged documents, the title history, the timber clearing, the full scope of what Meridian had done and what Hartwell and Prout had been doing to Walter ever since. Marcus Brennan listened the way Phil Garrett listened, without interrupting, and when David finished, Brennan sat back and looked at the documents spread across his conference table for a long moment. Your father hasn't settled, Brennan said. No, David said. Good, Brennan said. Because what's in these documents isn't a property dispute. It's a criminal enterprise that has been hiding behind civil procedure, and I've been doing this for 23 years, and I can tell you that I've seen maybe 4 cases in that time that were this clean, this documented, and this winnable. He closed the top folder. We're in pro bono, and I'm lead counsel personally, not one of my associates. When David told Walter, Walter sat with it for a moment. Why pro bono? Walter asked. Men like that don't work for free. He said some cases are worth taking because of what they are, David said. And I think he also just wants to be the one who takes Hartwell and Prout apart in a courtroom, because from what I understand there's some history there. The investigation team Brennan brought in was led by a former county assessor named Roy Briggs, who was a small, quiet man with the patient energy of someone who genuinely loved finding things that other people had tried to bury. and he went to work on Meridian's document trail with the thoroughness of someone who understood that the story was in the details, and that details did not lie if you looked at enough of them. What Roy Briggs found, over 11 weeks of digging through corporate filings, title records, permit applications, financial disclosures, and county archives, was a picture of deliberate and coordinated fraud that had been constructed with enough care to survive casual scrutiny, but not the kind of scrutiny Roy Briggs applied to it. The forged bill of sale had been prepared by a title company that Meridian had used exclusively for 6 years, and that shared a parent company with one of Meridian's primary investors. The notary whose stamp appeared on the document had died 14 months before the document was supposedly executed. The two witnesses whose names appeared on the signature line were both current employees of Meridian's development subsidiary, one of whom had received a significant bonus payment 3 weeks after the document was filed. There was more. Internal emails recovered through discovery showed that Meridian's principals had been aware of the ownership question before the clearing began, had discussed it in communications that their legal team had somehow failed to flag as responsive to Walter's discovery requests, an oversight that Marcus Brennan noted in a filing that the judge had responded to with language that suggested his patience with Hartwell and Prout was developing a measurable limit. The environmental attorney Brennan brought in, a woman named Sandra Fitch who spoke about tree law with the precision of someone who had built a career on it, had been out to the property with a forestry consultant and returned with findings that added a dimension to the case that Meridian's team had apparently not fully anticipated. The consultant's report documented 900 acres of cleared forest, including sections of genuine old growth identified through core sampling and historical aerial photography, with continuous canopy coverage of over a century. The timber value was significant. The ecological value under the relevant statutes was larger. And because the clearing had been willful trespass on land Meridian had never legitimately owned, the statutes allowed for treble damages on the full assessed loss. Sandra Fitch had written that number at the bottom of her report and circled it. Phil Garrett had whistled when he read it. Walter had not whistled. He had thought about his father pointing out chestnuts and oaks on a Saturday morning when Walter was 9 years old, and he had felt the thing in his chest that had been there since the day he drove out and found Pinecrest Estates become something harder and more purposeful. Corinne Marsh, perhaps sensing that the situation was evolving in ways that weren't favorable, had escalated her campaign in the weeks before the trial date was set, organizing a community meeting at the Pinecrest Clubhouse that 260 homeowners attended, where she presented Walter's lawsuit using a slideshow that described him as a speculative land claimant attempting to exploit a documentation irregularity to dispossess an established community. And she had been thorough enough in her preparation to have printed packets for attendees that included a timeline of events written entirely from Meridian's perspective and a contact sheet for the local media. The story that ran in the county paper the following week was not flattering to Walter. Corinne called him the morning it was published. "I wanted you to see that the community has a voice in this," she said, and there was a satisfaction in her tone that she wasn't entirely bothering to conceal. "This isn't just between you and Meridian anymore. 400 families are on the record now, and that record is going to follow this case wherever it goes." "Mrs. Marsh," Walter said, "I want you to listen to me carefully because I'm only going to say this once. Every call you've made, every email you've sent, every time you've shown up at my office or approached me in public, every meeting you've organized and every media contact you've made, all of it is documented, all of it is preserved, and all of it is going to be part of the record in this case. I want you to think about that before you call this number again." There was a pause on the other end that was different from her previous pauses, less composed, and when she spoke again, the satisfaction was gone from her voice and something more careful had replaced it. "Are you threatening me, Mr. Cobb?" "I'm informing you," Walter said and ended the call. 6 weeks later, Marcus Brennan called to tell him the trial date had been set and that Hartwell and Prout had reached out about settlement, and Walter stood in his kitchen and looked out at Margaret's garden and gave the same answer he had been giving since the first day he drove out and found his forest gone and his land covered in other people's houses. "No settlement," he said. "I want this in front of a judge." "I was hoping you'd say that," Brennan said. The courtroom was smaller than Walter had expected, a plain municipal space with fluorescent lighting and wooden benches worn smooth by decades of people sitting in them while their lives were being decided. And it struck him on the first morning as the kind of room that had no interest whatsoever in the drama of what happened inside it, which he supposed was appropriate. Drama was for people who weren't sure how things were going to go. Walter had spent enough time with Marcus Brennan in the weeks leading up to trial to understand, with the quiet certainty of a man who had spent his life reading situations accurately, that Brennan was not walking in here to find out how this ended. He was walking in here to end it the way he had already decided it would end. Hartwell and Prout had sent 4 attorneys, led by a senior partner named Douglas Fenn, who was tall and silver-haired, and had the practiced courtroom manner of a man who had learned long ago that looking untroubled was itself a form of argument. He shook hands with Brennan before the proceedings began with the collegial ease of opposing counsel who have done this many times, and Walter watched the exchange and thought that Fenn looked like a man performing confidence rather than possessing it, which was a distinction Walter had learned to recognize over 40 years of dealing with people who wanted something from him. Judge Caroline Howell had been on the bench for 16 years and had the compact, economical manner of someone who had stopped tolerating inefficiency a long time ago. She had read the pre-trial briefs. That much was evident from the way she looked at both counsel tables when she came in, a look that suggested she had formed preliminary views and was prepared to have them confirmed or challenged but not wasted. Marcus Brennan's opening was not long, which was itself a statement. "Your Honor," he said, standing without notes, "this case is, at its foundation, straightforward. Walter Cobb owns this land. He has owned it through direct and unbroken family title for over 100 years. The defendant, Meridian Land Group, knew he owned it, discussed the ownership question internally before they ever broke ground, and proceeded anyway, after first manufacturing a fraudulent transfer document to provide themselves with the appearance of legitimacy. Everything that has been built on that land, every permit that was pulled, every home that was sold, every tree that was cut, flows from that single fraudulent act. We will demonstrate all of this with documentary evidence, expert testimony, and the defendant's own internal communications. When we are finished, there will be no ambiguity about what happened here or why." He sat down. Douglas Fenn's opening was considerably longer and considerably more elaborate, and it rested on 3 pillars that Walter had heard in various forms since the first phone call to Meridian: the recorded transfer document, the good faith development argument, and the economic reality of what had been built. And Fenn delivered all 3 with the smooth assurance of a man who had made juries believe harder things. Except there was no jury, and Judge Howell watched him from the bench with an expression that gave nothing away and required everything that was said to earn its place in the room. Brennan called Roy Briggs first. Roy Briggs on the stand was the same as Roy Briggs in a conference room: quiet, methodical, entirely without theatrics, and devastating in direct proportion to those qualities. He walked through his investigation with the patience of a man who understood that the power of what he had found lay entirely in the accumulation of specific, documented, verifiable detail, and he did not rush any of it. He explained the corporate relationship between Meridian and the title company that had prepared the fraudulent bill of sale, producing filings that showed the shared parent company, the overlapping investors, the 6-year exclusive relationship. He explained the notary stamp, producing the death certificate of the notary whose name appeared on the document. Noting the 14-month discrepancy between the date of death and the date, the document was supposedly executed with quiet precision, as though he were simply reading a grocery list rather than establishing that someone had used a dead man's credentials to forge a property transfer. Douglas Fenn objected 3 times during Roy Briggs's testimony and was overruled 3 times. And by the 3rd overruling, Judge Howell's response had acquired a brevity that suggested she would prefer he save his objections for something that merited them. Brennan then produced the internal Meridian emails. They had been recovered through discovery after Marcus Brennan filed the motion noting Hartwell and Prout's failure to produce them as required, and the story they told was not complicated. 14 months before the clearing began, a Meridian vice president named Thomas Greer had written to the company's founder and CEO, a man named Richard Halston, noting that a title search had turned up an ownership question on the parcel and recommending they pause while it was resolved. Halston had responded the same day, in an email that Brennan read into the record in its entirety with the measured, unhurried tone of a man allowing words to do their own work, saying that the parcel was too valuable to let a title question derail the timeline, that their people would handle the documentation, and that Greer should proceed with the clearing schedule. The courtroom was very quiet after Brennan finished reading. Judge Howell made a note. Douglas Fenn's cross-examination of Roy Briggs was professional and thorough and accomplished very little, because Roy Briggs had not offered an opinion in his testimony. He had offered documents, and documents do not waver under cross-examination. Fenn challenged the interpretation of the corporate relationship between Meridian and the title company, and Briggs agreed calmly that other interpretations were possible, and then explained methodically why the documentary evidence supported only one of them. Fenn suggested that the email exchange between Greer and Halston was being taken out of context, and Briggs said that he had provided the complete email chain and that the court was welcome to read all of it, which it already had. Fenn sat down. The forensic document examiner came next, a woman named Dr. Patricia Home, who had testified as an expert witness in federal courts in 11 states, and who approached the stand with the no-nonsense efficiency of someone who had answered the same questions enough times to have stopped finding them interesting, but had not stopped finding accuracy important. She had examined the bill of sale using 4 separate analytical methodologies, she explained, including ink composition dating, paper fiber analysis, signature pressure mapping, and a comparative analysis against 15 authenticated samples of Walter Cobb's signature obtained from contracts, tax documents, and business filings spanning 30 years. In my professional opinion, she said, in response to Brennan's direct question, the signature on the bill of sale was not produced by Walter Cobb. The pressure distribution is inconsistent with his authenticated samples across all 15 reference documents. The ink composition dates the signature to a period no earlier than 3 years after the document's stated execution date. And the letter formation in 3 specific characters, the W, the C, and the lowercase b, shows structural patterns that are not present in any of the authenticated samples, and that suggests the signature was produced by someone copying from a limited reference set rather than signing naturally. She had brought exhibits, large printed comparisons mounted on foam board, and she walked through each one with the thoroughness of a teacher who intended to make sure the lesson was learned. And Judge Howell leaned forward slightly during the signature comparison portion in a way that Walter noticed and filed away. Douglas Fenn's cross-examination of Dr. Home lasted 40 minutes and produced nothing useful for his client, a fact that appeared to cost Fenn something in terms of the composure he had been maintaining since the first morning. Because when he sat down after her final answer, there was a tightness around his jaw that hadn't been there before. Sandra Fitch took the stand after lunch on the second day, and she brought the forestry consultant's report and her own analysis, and she laid out the timber case with the methodical precision that Marcus Brennan had described when he introduced her to Walter, and the numbers she put into the record were the numbers that had made Phil Garrett whistle. She explained tree law to Judge Howell not in the condescending way of an expert who assumes ignorance, but in the thorough way of one who wants the record to be complete, covering the statutory framework for unauthorized clearing, the distinction between negligent and willful trespass in the application of damages, and the specific provisions that allowed for treble damages in cases where the clearing party had knowledge of the ownership question before proceeding, which the Halston email had established beyond any reasonable dispute. She then presented the forestry consultant's findings regarding the old-growth sections, and this was the portion of her testimony that Walter found the hardest to sit through, not because it was difficult to follow, but because it was precise and documented and permanent, a record of destruction that had once been living things his father had known. And hearing it enumerated in cubic feet of timber and acres of canopy and centuries of biological continuity, reduced to line items in a damages calculation, was a particular kind of grief that he hadn't anticipated. The total figure Sandra Fitch presented to the court, inclusive of timber value, ecological remediation costs, and the treble damages applicable under the willful trespass statute, was a number that produced an audible reaction from the Hartwell and Prout table that Douglas Fenn suppressed quickly, but not quite quickly enough. Judge Howell looked at the number for a moment and then looked at Douglas Fenn. "Counselor," she said, "I'll give you an opportunity to address the timber damages calculation in your case in chief, and I'd encourage you to bring something substantive." Fenn said that he would, Your Honor, and his voice was steady, but the tightness around his jaw had spread. Karen Marsh had been in the courtroom for all of it, sitting in the public gallery with a rotating group of Pinecrest homeowners who came and went over the course of the trial. And Walter had been aware of her presence the way you are aware of something at the edge of your peripheral vision that keeps moving. She sat very straight and took notes on a legal pad and whispered to the homeowners beside her. And on the second afternoon, she had made eye contact with Walter during a recess in a way that was meant to communicate something, resolve perhaps, or defiance. And Walter had looked back at her with the same expression he had used in his office and at the restaurant, the expression that communicated simply that he had assessed the situation and was not concerned, and she had looked away first. Brennan had saved Karen for the third day. She was not a named defendant. The defendants were Meridian Land Group and Richard Halston personally, whom Brennan had added to the suit by name after the emails surfaced. But Brennan had subpoenaed her as a witness, and she took the stand with the posture of a woman who had decided to treat being subpoenaed as an opportunity rather than an imposition, smoothing her blazer as she sat down and looking at Brennan with the alert, cooperative expression of someone who intended to be very helpful in ways that happened to serve her preferred narrative. Brennan let her establish herself for a moment and then began. He asked her about the calls to Walter's phone, and she acknowledged them pleasantly, describing them as good-faith community outreach efforts aimed at finding a peaceful resolution. He asked her about the emails, and she described them the same way. He asked her about the office visits, and she said she had simply wanted to speak with Mr. Cobb directly about the impact on residents, which she felt was a reasonable thing to want. Then Brennan picked up a folder. "Mrs. Marsh," he said, "I'm going to read you something from an email you sent to Mr. Cobb on the 14th of last March, and I'd like you to explain it to the court." He read the relevant section, which included Corinne's observation that Walter's stress levels from litigation at his age were something he should discuss with his doctor and her expression of concern for his health, and he asked her to describe the intent behind that particular passage. Corinne said that she had genuinely been concerned about Mr. Cobb's well-being. Brennan nodded and picked up a second folder. He then produced the phone records, which showed 41 calls from Corinne's number to Walter's over a period of 9 months, and he went through them with her one by one, asking her to confirm the date and approximate content of each, and Corinne's composure remained intact through the first dozen or so before it began to develop the particular quality of a performance that is aware it has lost its audience. Brennan asked her about the community meeting she had organized, and the media outreach and the printed packets she had distributed describing Walter as a speculative land claimant, and he asked her to explain how those activities constituted good faith outreach toward peaceful resolution rather than a coordinated campaign to create public pressure on a litigant. And Corinne's answer was long and elaborately constructed, and Brennan let her finish it completely before asking his next question, which was whether she had been in communication with Meridian's legal team during the period in which she was conducting this outreach. The pause before Corinne answered that question was not long, but it was the wrong length. She said that she had been in contact with Hartwell and Prout on matters relating to the HOA's legal position in the case. Brennan asked whether those communications had included discussions about her outreach activities directed at Mr. Cobb specifically. She said that she couldn't recall the specific content of every conversation. Brennan produced 3 emails between Corinne Marsh and a Hartwell and Prout associate in which her outreach activities were discussed, coordinated, and in 2 instances specifically directed, and he placed them on the screen where Judge Howell could read them, and he read them aloud for the record, and Corinne Marsh sat on the witness stand and looked at the middle distance with the expression of someone who has just watched the last exit close. Douglas Fenn's objection was overruled before he finished making it. Judge Howell read the emails twice, and made a longer note than she had made at any previous point in the trial. Fenn's case in chief was 2 days of witnesses and documents that attempted to establish the legitimacy of the transfer documentation, the good faith nature of the development, and a counter-analysis of the timber damages that his own expert presented with visible discomfort under the weight of Sandra Fitch's methodology. The witnesses were competent and the documents were numerous, and none of it answered the Halston email or the dead notary or doctor Holmes' signature analysis in any way that moved the needle, and by the end of the second day of Hartwell and Prout's presentation, Walter had the sense that Douglas Fenn knew it too, and that the silver-haired composure across the aisle was now entirely performance, a professional obligation rather than a genuine state. Closing arguments were on a Friday morning. Brennan's closing was 18 minutes long and contained no rhetorical flourishes and no emotional appeals, and was simply a clean, sequential reconstruction of everything that had been established, each element connected to the next with the logical precision of a structure being assembled in front of the court. And when he was done, the case was not a story or an argument. It was a shape, complete and self-supporting, that required nothing additional from anyone. Fenn's closing was 40 minutes and was genuinely impressive as a piece of advocacy, a skilled attorney doing everything that could be done with materials that were not adequate to the task. And Walter respected the effort even as he sat in his chair and felt the certainty in the room press in like weather. Judge Howell took the weekend. She delivered her ruling on Monday morning, and she was thorough in the way that judges are thorough when they want the record to be unassailable on appeal, walking through each element of the case with the same sequential precision Brennan had used in his closing. And the ruling went the way it went, and each finding landed in the courtroom with the solid, final sound of something being settled permanently rather than temporarily. Walter Cobb owned the land, had always owned it. The transfer document was fraudulent, the notarization was fraudulent, the witness signatures were fraudulent, and the evidence established that the fraud had been planned and executed with full knowledge by the principals of Meridian Land Group. Richard Halston was personally liable. The timber damages were assessed at the full amount Sandra Fitch had presented, and the treble damages provision applied, and that number was now a judgment. All 412 homes had been built on land that Meridian had never owned, and had no legal authority to develop or sell. The judge paused there, and the courtroom was as quiet as it had been at any point in the proceedings. She noted that the homeowners who had purchased properties in Pinecrest Estates were third parties whose interests required separate consideration, and that her ruling did not resolve the question of their status, but established clearly that their titles derived from a fraudulent chain and would need to be addressed in subsequent proceedings. She looked at Douglas Fenn. The court is also referring this matter to the district attorney's office, she said, with a recommendation that the conduct of Meridian Land Group and its principals be reviewed for potential criminal charges, and I want to be very direct about that recommendation. This was not a documentation error or a title dispute of the kind this court sees routinely. This was a deliberate and sustained fraud, and the record of this case will reflect that characterization. She looked at Walter for a moment before she gathered her materials. Mr. Cobb, she said, your family's title to this property is confirmed. What happens next is yours to decide. She left the bench and the room began to move again, and Walter sat in his chair while Marcus Brennan shook his hand and Phil Garrett shook his hand, and David, sitting in the gallery behind him, put a hand on his shoulder, and he looked straight ahead at the wall of the small plain courtroom and thought about a Saturday morning when he was 9 years old and his father's hand pointing at an oak tree that had been standing since before anyone currently alive had been born. Then he stood up and put on his coat and began to think about what came next. The calls started coming before Walter even got home from the courthouse. Homeowners mostly, some angry, some frightened, some both at once, having heard through the subdivision's communication channels that the ruling had gone against Meridian and understanding, with the particular clarity that comes when something threatens your mortgage, that the ground under their houses had just become legally complicated in ways they hadn't fully processed when they bought in. Walter let the calls go to voicemail and drove home and sat at the kitchen table with a cup of coffee and looked at the wall for a while, the way he did when he was working through something that required more than one angle of approach. He had not yet decided what he was going to do, and he was not going to be rushed into deciding. What he had not anticipated was the letter that arrived 3 days later. It came in a plain envelope with a return address he didn't recognize, and inside was a single typed page from a woman named Alina Voss, who identified herself as a retired schoolteacher living at 14 Pinecrest Circle, and who wrote without self-pity and without manipulation and simply told him the truth of her situation, that she was 73 years old, that her husband had died 2 years prior, that she had sold the house they had shared for 31 years to buy into Pinecrest because the maintenance had become too much alone, that she had used essentially everything she had to do it, and that she understood completely if he needed to reclaim the land but wanted him to know, from one human being to another, that she had nowhere else to go. Walter read the letter 3 times. He put it in his shirt pocket and kept it there for 2 days. It was David who brought him the first piece of unexpected news, calling on a Thursday morning with the focused energy of someone who has been doing significant homework. Dad, he said, you need to know something about Meridian before you make any decisions because it changes the financial picture considerably. He paused. Richard Halston has been moving assets. Walter set down his coffee. Halston had apparently anticipated the judgment with enough lead time to begin restructuring his personal holdings, transferring real property and investment accounts into his wife's name and into a family trust established 3 months before the trial began, in what David described as a transparent but potentially effective attempt to insulate his personal wealth from the judgment against him. The Meridian corporate entity itself was thinly capitalized relative to the size of the judgment, having been structured in the way that development companies often are structured, with the valuable assets, the lots, the infrastructure, the development rights, having already been monetized through the home sales and the proceeds distributed upward through a layered corporate structure that now appeared to contain very little of value at the bottom where the judgment sat. He's trying to walk away, Walter said. He's trying to walk away, David confirmed. And he may have started moving things early enough that some of it sticks. Walter was quiet for a moment. Get Brennan on the phone, he said. Marcus Brennan had not been surprised by any of this. It turned out, because Roy Briggs had been watching Meridian's corporate filings since before the trial ended and had flagged the asset movements as they happened, and Brennan had already prepared a fraudulent transfer action under the state's version of the Uniform Voidable Transactions Act, which allowed creditors to claw back assets moved with intent to defraud, and he had filed it the morning after the judgment came down. The family trust is going to be the fight, Brennan said, because Halston's attorneys are going to argue it was established for legitimate estate planning purposes, and we're going to argue that the timing is a fairly compelling indicator of intent. The wife's assets are more straightforward. Transfers between spouses in anticipation of a judgment are well-established fraudulent transfer territory. How long? Walter asked. Months, Brennan said. But Roy found something else this morning that you need to hear. What Roy Briggs had found, in the course of pulling apart Meridian's corporate structure layer by layer, was that Pinecrest Estates was not the only development Meridian had built using the same methodology. There were two other subdivisions in adjacent counties, both developed within the past 8 years, both involving parcels where the title history showed the same pattern of irregularities, recorded transfers that had been executed using the same title company, notarized by credentials that didn't survive scrutiny, with internal documentation suggesting that ownership questions had been identified and suppressed rather than resolved. Walter sat with that for a long moment. So this wasn't an experiment, he said. This was a business model. That's what it looks like, Brennan said. The district attorney's office had been moving faster than anyone expected, apparently because one of the assistant DAs assigned to review the court's referral had recognized Richard Halston's name from an unrelated investigation that had been dormant for 2 years, involving a commercial property transaction in the county seat. And the two matters together had elevated Halston from a civil judgment to a criminal target with sufficient momentum that a grand jury had been convened before Walter's fraudulent transfer action had even been fully briefed. Halston was indicted on a Tuesday morning, 6 weeks after the judgment, on 12 counts that included forgery, fraudulent conveyance, conspiracy to commit fraud, and 2 counts related to the asset transfers made after the judgment. His CFO, a man named Dennis Park, who had apparently decided that his loyalty to Richard Halston had a specific and recently revised price, had agreed to cooperate with the prosecution in exchange for a reduced charge, and the cooperation agreement had been signed before the indictment was announced, which meant that by the time Halston's criminal attorneys were standing at a podium outside the courthouse talking about their client's intention to vigorously defend himself, the prosecution already had his CFO's testimony and his CFO's documents, and his CFO's recollection of 12 years of Richard Halston's business practices. David called Walter when the indictment was announced. How do you feel? David asked. I feel like it's not finished yet, Walter said. He was right about that. The twist came from a direction Walter hadn't been watching, which was the Pinecrest HOA itself, and specifically from Karen Marsh, who had apparently spent the week since her testimony calculating her exposure and arriving at a number she didn't like. She called Walter on a Wednesday evening, and the voice on the phone was not the voice of the woman who had called 41 times over 9 months with the performed patience of someone managing an inferior. It was the voice of a woman who had spoken with her own attorney and understood specifically what her coordination with Hartwell and Prout meant in terms of her personal liability for the harassment campaign. And she was calling, she said, because she wanted to discuss something before it became a formal legal matter. Walter listened. What Karen Marsh had, it turned out, was documentation. She had kept everything, every email from Hartwell and Prout directing her outreach activities, every instruction she had received about which homeowners to deploy in personal appeals, every communication in which Meridian's legal team had explicitly shaped her campaign against Walter, while maintaining the fiction that she was acting as an independent community advocate. She had kept it, she said, because she was not a stupid woman and had understood from the beginning that she was being used and had wanted insurance. You were doing their work for them, Walter said. Yes, she said, and the word had the particular flatness of an acknowledgement that has cost something. And I told myself it was for the community, and some of it was, but I knew what I was doing and I knew why they wanted me doing it. And I kept the documentation because I knew that if this went wrong, they would let me stand in front of it alone. Walter was quiet for a moment. What do you want, Mrs. Marsh? He said. I want to give you everything I have, she said, in exchange for a release of personal liability on the harassment claim. And I want to tell you something that I think you need to know before you decide what to do with the homeowners. Walter told her to go on. Richard Halston knew, she said, that there was a significant chance this would end exactly the way it ended. And 18 months ago, before the trial, he quietly sold his personal interest in the Meridian entity that holds liability for the development to an offshore holding company registered in the Cayman Islands. And that company is owned through a series of shell corporations that Dennis Park put together specifically to make it impossible to trace back to Halston. She paused. The CFO who flipped he built the structure. He knows exactly how it works. And he has documents that show the offshore entity received the proceeds from 206 home sales in Pinecrest Estates, which is money that should be available to compensate the homeowners and satisfy your judgment, if anyone can get to it. Walter sat very still. Why are you telling me this? He said. Because, Karen Marsh said, and there was something in her voice that might have been exhaustion or might have been something closer to belated conscience. Those homeowners trusted me. They trusted me to look out for this community, and instead I was carrying water for a man who had already figured out how to leave them holding the bag, and I am not going to let that be the last thing I did in that role. Marcus Brennan, when Walter called him the next morning, was quiet for a long moment after Walter finished. She has the coordination emails, he said. She says all of them, Walter said. And she's saying Park has documentation of the offshore structure. That's what she says. Another silence. Walter, Brennan said, and he used the first name deliberately, which he rarely did. If Park's cooperation agreement with the DA includes this offshore structure, and if Karen Marsh's documents establish the coordination the way she's describing, then Halston doesn't have a place to hide. Not in the civil case and not in the criminal one. The cooperation agreement, it emerged through the DA's office over the following weeks, did include the offshore structure, and Dennis Park had been considerably more forthcoming about it than Halston's criminal attorneys had apparently anticipated, because the indictment was superseded 3 weeks later with an amended version that added 8 counts including money laundering and international fraud. And a parallel civil asset recovery action was filed jointly by the state attorney general and a federal prosecutor, whose office had developed an interest in the Cayman Islands entity. Richard Halston's bail was revised upward considerably. The asset freeze that followed the superseding indictment was comprehensive enough to reach back through the shell corporation structure and touch the offshore accounts, and the amount frozen was substantially larger than anyone had publicly discussed. And when Roy Briggs reviewed the numbers and called Walter to walk him through them, Walter sat at the kitchen table and looked at the wall for a long time. It's enough, Roy said simply. To pay the judgment, compensate the homeowners at fair market value for the land under their homes, fund the timber remediation, and have money left over. Walter thought about Elinor Voss's letter, which he had moved from his shirt pocket to the kitchen drawer where he kept things that mattered. All of it gets paid, Walter said. Every homeowner's. Fair market value for the land, properly documented, proper deed, clean title. Nobody loses their house. That's going to take some time to structure, Roy said. Then we structure it, Walter said. The HO, a dissolution and restructuring, took longer than the asset recovery, partly because it required negotiating with the homeowners as a group, and partly because the new covenants Walter's attorneys drafted were sufficiently unusual that several of the homeowners' personal attorneys wanted time to review them before their clients signed, which Walter considered entirely reasonable. The common areas were preserved, the park, the clubhouse, the roads, the infrastructure that people's daily lives had organized themselves around, and a new HO entity was formed to manage them, with a board structure and dues framework and the standard operational provisions that such organizations required. And then the provisions that were not standard. Walter had been clear with Brennan about what he wanted, and Brennan had drafted language that was precise and unambiguous, and that every homeowner's attorney had read carefully before advising their clients to accept it, which they all ultimately did because the alternative was considerably less attractive. Walter Cobb held permanent veto power over any decision of the Pinecrest HO board. Any resolution, any rule change, any expenditure above a defined threshold, any covenant modification, all of it required his affirmative non-objection to take effect. He did not need to attend meetings or participate in governance in any ongoing way. He simply retained in perpetuity and transferable to his heirs the right to say no. and he retained the right to dissolve the board entirely at any time, for any reason, with 30 days written notice, at which point governance of the common areas would revert to a management company of his choosing until a new board was formed under the same covenant structure. The homeowners had not loved these provisions. Several of them had pushed back through their attorneys, arguing that the veto power was an unreasonable encumbrance on a residential community's right to self-governance, and Walter had listened to those arguments through Brennan and had acknowledged that they were not unreasonable arguments, and had then noted that the alternative governing document was the one where he reclaimed the land entirely and everyone found somewhere else to live, and the pushback had resolved itself fairly quickly after that. Corinne Marsh had signed the new covenants without objection, and had resigned from the HO aboard the same day and had moved out of Pinecrest Estates 2 months later. Walter did not know where she went and did not ask. The harassment suit he filed against her personally was settled for a number that his attorney described as appropriate, and the settlement included her full cooperation in the criminal case against Halston, which she had already committed to, but which was now contractually enforceable. Richard Halston pleaded guilty to 7 of the 12 amended counts on the morning his criminal trial was scheduled to begin, in the particular manner of a man who has been shown the complete shape of what the prosecution has, and has done the math on what a jury would do with it. The plea agreement included full cooperation with the civil asset recovery, the surrender of all interest in the offshore entity, and a sentencing recommendation that his attorneys had negotiated down from what the DA had originally sought, but that still represented a significant portion of the next decade of Richard Halston's life. Dennis Park received his reduced charge and a suspended sentence and moved to another state. The 2 other subdivisions in the adjacent counties became the subject of their own proceedings, in which Walter was not directly involved, but which used the record from his case as their foundational framework, and which the affected landowners in those counties had engaged their own attorneys to pursue with the energy of people who had been handed a roadmap by someone who had already made the trip. On a Thursday morning in early November, 14 months after Walter had first pulled his truck to a stop in front of the Pinecrest Estates sign, a crew arrived at the northeastern boundary of the property where the subdivision ended and the remaining forest began, and they began the process of marking the boundary line for the fence Walter had designed over many quiet evenings at the kitchen table. Beyond the fence line, the surviving forest was intact, the 800 or so acres that Meridian's clearing operation had not reached before it was stopped, and Walter had walked it twice in the preceding weeks with the same attention his father had given it, relearning the land, finding the sections that matched his memory and the sections that had changed in the decades since he'd last walked them. Noting the places where the old growth remained, and the places where the boundary between cleared and uncleared land had left a ragged edge that would need decades to recover. He had also hired a reforestation specialist, a younger woman named Dr. Keeley, who had looked at the cleared sections and described a phased planting plan with the particular passion of someone who loved trees the way other people loved buildings. And they had walked the cleared areas together, and she had talked about what could be done, and over what timeline, and Walter had listened and approved the full plan and told her to start as soon as the ground was ready. The house site had been selected on a small rise in the surviving forest with a natural clearing that required almost no intervention, and the builder Walter had kept in mind for years had come out and walked it with him, and they had stood on the rise and looked at the tree line and talked through the plans Walter had been sketching for longer than the legal case had taken: the full front porch, the wood stove, the room enough for sons and grandchildren. The builder had asked him what he wanted the house to say, the way good builders sometimes ask that question when they understand that a house is rarely just a house. Walter had looked at the tree line for a moment. "I wanted to say it's been here a long time," he said, "and that it's going to be here a lot longer." He thought about Elinor Voss's letter, which was now framed on the wall of his home office alongside the original deed his grandfather had recorded in 1921, the 2 documents occupying the same wall in a pairing that Walter found meaningful in a way he hadn't fully articulated but didn't need to. He had written Elinor back months ago now, a short letter in his own hand that said simply that she was welcome to stay in her home, that her title would be cleared and her deed recorded properly, and that he hoped she would be comfortable there for as long as she wanted. She had written back once more, a shorter letter than the first, and it said only "thank you," and she hoped someday to say it in person, and Walter had folded it and put it in the drawer with the first one. He was standing at the fence line on a cold November morning, watching the crew work when his phone rang, and he looked at the screen and saw it was David. And he answered, and David told him that the asset recovery had been finalized, and the compensation fund for homeowners was fully capitalized, and the administrator they had appointed was ready to begin processing claims. Walter looked at the tree line where his forest began. Good, he said. How's the fence coming? David asked. It's coming, Walter said. There was a comfortable silence between them, the silence of a father and son who have been through something together and are standing on the other side of it. You know, David said, when this is all done and the house is built, I'm going to need you to actually answer your phone when I call. I answered just now, Walter said. You know what I means. Walter watched the crew work for another moment, watched them drive a stake into the ground at the corner of what had always been his land and would remain his land, and would eventually belong to his sons after him and their children after them, the way his grandfather had intended when he purchased it in a time when purchasing land meant permanence and intention, and a declaration made to no one in particular. Come out when the porch is done, Walter said. Bring the kids. He put the phone in his pocket and stood in the cold morning air and breathed in the particular quality of it, the pine and the clay and the faint wood smoke from somewhere distant, and he felt the hard thing that had lived in his chest since the day he drove out and found his forest gone begin, very slowly, to become something else. Not gone. He didn't think it would ever be entirely gone. But changed. Settled. Load-bearing in a different way. He turned up his collar against the cold and watched his fence go up on his land, and after a while he went home.
I would like to thank you for watching the video to the end. To encourage us to make more videos, please like, subscribe, comment, as well as share.